anyways, it looks like we're on the right track anyway in regards to the pandemic, guys. You know, the restrictions are being lifted, which was very excited when we were very excited when we saw that last week. And of course, now the vaccine is going to be available, and hopefully everybody will be vaccinated if they want to be before at the end of the summer. Who knows what's going to happen? But what does that mean for employers and employees? So today we have attorneys Bob Kilroy and Amanda Baer. They're joining us today. They're experts in the employment and labor laws, and they are attorneys at Mirick O'Connell. They have, I think you're in Westboro and Worcester, if I have that correct. I'm not sure if there's other offices, but we're in very good hands this morning. So thank you both for joining us, and I'll let you get on with the show.
Excellent. Well, thanks, Laura. Appreciate it. And our firm has been big supporters of Laura and the chamber for years, even going back before Laura's time.
Yep.
So we love to being involved and look forward to when we can actually have a beer, side by side as opposed to just over Zoom. So Amanda and I plan to move fairly quickly. We think we can probably get this done in about 30 minutes or so, allow time for questions as well. The roadmap, we're going to cover two broad topics. The pandemic's brought a whole host of employment-related concerns and problems for employers and owners and HR professionals to deal with. The two we'll tackle today is mandating COVID vaccines. Can you mandate? Should you mandate? Amanda's going to cover that. And then, because so many of us are working remotely and so many folks probably have gotten used to it and enjoy it, the commute is from your bedroom to your kitchen. Some folks may not want to return. They may want to remain remote. And what's the rights and obligations of the employers to getting them back to work if they decide to mandate their return to work? So with that said, Amanda, you've got the vaccine.
Great. Thank you, Bob. Hi, everyone. My name is Amanda Baer, as Bob mentioned. I'm a labor and employment attorney at Mirick O'Connell. With respect to vaccines, we're seeing two major threshold questions. The first is, can employers mandate that their employees receive the vaccines? The short answer is the EEOC says yes, so that's the Equal Employment Opportunity Commission. Employers can mandate their employees to get vaccinated. There are challenges to that mandate since the vaccines are only authorized under the emergency use by the FDA. But in general, employers can, according to the EEOC, mandate employees receive the vaccine. The next question, though, however, is should employers mandate that their employees receive the vaccine? And for that, we say no. Employers should probably not mandate that their employees receive the vaccine because it opens a whole host of issues that the employer will need to consider and a lot of vulnerabilities for potential claims, which I'll go into. So first, the first area that will be of a contention is if an employer mandates that its employees receive vaccines, the employer may have employees who ask for an exception to that mandate due to a disability that the employee has. If an employer does mandate that employees receive the vaccine and someone asks for an exception to that, the employer then needs to engage in the interactive process with the employee and determine if the employee would be a direct threat to the workplace if unvaccinated, and if the employee can be reasonably accommodated in their request. So that is a very fact-intensive analysis, and it's going to vary employer by employer and workplace by workplace. Some considerations that will likely be in play are the employee's physical work area, because if you have an employee who's working in a public-facing role or in a series of cubicles, that may be a different analysis than if you have an employee who is driving a vehicle by themselves or otherwise isolated. Other considerations will include the vaccination status of other members of the workforce, as well as the possibility of the employee to work remotely. And Bob will get into some more of those considerations. Another potential accommodation would be granting the employee some type of leave of absence. And that can be very tricky because who knows how long that leave of absence the employee would need. If their disability will resolve and they can't obtain the vaccine in a few months from now. Considerations of that sort. So there's a whole host of different issues that the employer will need to consider. And that is just complicated by the fact that we don't have any case law on these points yet. So it's difficult to predict how the courts and the MCAD will resolve any types of disability discrimination or failure to accommodate claims here. In addition to employees requesting an exemption from the mandates due to their disability, employees may also request an exemption due to their sincerely held religious belief. So there are several religions that I'm aware of that prohibits a strong word, but that don't encourage their followers to obtain vaccines. So we are seeing several employees requesting exemptions under or due to their religious belief. And employers here can run into issues if they attempt in any way to challenge the employee's religious belief. So I had one employer recently who wanted to ask employees to quote the specific Bible verse that prohibits them from getting the vaccine. And I strongly advised against that. Employers are not going to win if they're challenging the employee's sincerely held religious belief, except in very certain egregious situations. And I think, it made news yesterday that a certain religion was saying that the Johnson & Johnson vaccine may be violative of their moral standards because of the way in which it was manufactured. So that will just add further complications for the employer if they have an employee coming to them saying that they can only obtain a certain type of vaccine and not a different one. So with all that said, mandating employees to obtain a vaccine can open up a whole host of issues for employers. What we recommend instead is that employers encourage their employees to obtain the vaccine, and they can incentivize employees to obtain the vaccine. And some ways to do that would be to offer, additional paid leave for the employee to use when they're going to get the vaccine, as well as potentially some additional paid leave if the employee is suffering any side effects from the vaccine. And there's some other potential incentives as well. Another complication with vaccines is that even if an employer does not mandate that its employees receive the vaccine, an employer instead is just encouraging it, employers must be careful if they're partnering with any third-party administrators and giving employees the ability to get the vaccine at the workplace or through that third-party administrator. So for example, the flu shot, the firm has a pharmacy come in and they can give us the flu shot in a conference room. That's going to be more challenging with the COVID vaccine because the EEOC has come out and said that the administration of the vaccine can reveal information about the employee's disability or genetic status, and the employer really needs to distance themselves from the administration of the vaccine. So while this isn't even a possibility yet, to my knowledge, what we would recommend is that if employers are mandating employees receive a vaccine or just encouraging it, that they just accept a doctor's note stating that the employee received the vaccine or some other record that's very, very just vague and basic, and that the employer not seek more information about reasons why the employee could not receive the vaccine. So that is it for vaccines. It's a very complicated issue, so we'll take questions on this at the end, but now Bob's going to talk about the remote workforce.
Great, thanks, Amanda. So turning our attention there, you could have employers that are incentivizing, encouraging employees to get the vaccine, but not everyone's going to get it possibly. And there's going to be a fear out there, if I return back to work, am I going to expose myself and family members and all the rest of it? So you've got folks working remotely and you say, time to come back to work. Let's assume it's June, right? June or July, the vaccine's been rolled out more fully. And you have an employee say, the virus is still out there, the pandemic's still ongoing, and I'd like to continue to work remotely. Can you require them to come back? Next slide, please. And the general rule is you can mandate them to come back to work on site. You've got every right to do so. You just want to be mindful of a couple of exceptions that I'll go over next. So the first one is you could have an employee with a pre-existing mental illness or disorder. And typically we're talking something that's diagnosed, not general anxiety or general fear or worry, but an actual anxiety disorder that has a medical diagnosis, obsessive compulsive disorder, post-traumatic stress disorder. Any of those would be deemed disabilities under the Americans with Disabilities Act. And you would need to look to whether or not you can reasonably accommodate them in that disability, right? And reasonably accommodate is enable them to be able to do the essential functions of the job in a way that accommodates their concern for being on site. And you may or may not be able to do so. We'll talk about that in a moment. But let's take beyond that, just the general anxiety, right? The general fear that's out there. You know, I don't want to get COVID. I'm concerned about it. You know, I'm up at night worrying about it. And I don't have a medical note. I don't have a diagnosis of an actual anxiety disorder. This is the type of thing that people just worry about. The answer there is that standing alone is not a disability. That's not enough to get them an exception to being mandated to come on site. Now, if someone came forward and told me that they had generalized fear and anxiety, I would ask for a doctor's note to substantiate that in case, in fact, they actually go above and beyond just the general fear to an actual disorder. How about the employee who's got this pre-existing condition, right? They have asthma, they have Crohn's disease, some other immunocompromised disease. Prior to the pandemic, they came to work every day. They worked right beside you every day. They do their job, no problem. Now that the pandemic has hit and they've been working remotely, they continue to worry, if I come back and if I get it, and there's no guarantee, right, that they're going to get it if they come back, it could be problematic because of the comorbidities that they face. What do you do in that situation? Factors to consider, first off, is the request to work remotely indefinite? If they're saying, I'm concerned about the workplace and I don't ever envision coming back, the answer is absolutely not. You don't have to accommodate that. Now, the reality is at some point in time, we're going to reach what's called herd immunity because so many people get vaccinated, or people have already had COVID. In that case, you're not likely to have an indefinite need for an accommodation. So although you don't have to accommodate something indefinite or long term, I don't see this as a real viable defense because I think, you know, by September or so, that the indefinite thing's probably gone away. More importantly, can the individual do all their job functions remotely? And there are some jobs, right, that if I'm an accountant, I can probably do all my job functions remotely. As a lawyer, I can actually do all my job functions by and large remotely unless I'm called into court or something like that. I can do a lot of it over Zoom. I can do all my research online, those type of things. But there's those jobs that you can't do that, right? There are some jobs that require face-to-face contact with patients, with customers. A receptionist can't do her job remotely, you know, those type of things. You never have to excuse an essential function. So if the individual is saying, I want to continue to work remotely, and let's assume they've worked remotely the last 10, 12 months, but now you feel like, all right, time to come back to work, and there are vaccines out there. Could you order them back in? Yes, you could. You could say, it's no longer reasonable. We're not going to forget about or forgive the essential functions that you should have been doing all along, and we're going to require you to come back on site. The other thing to keep in mind is an employee is subject to or eligible for any reasonable accommodation that's effective, not any reasonable accommodation that's their choice. So you might have two different types of accommodations, one of which is, I want to stay remote. Another one of which is, you can say, no, I'm going to have you come to work on site where you can do all the essential functions, and we're going to put in safeguards, social distancing, mandating face mask use, maybe having them in a private office, maybe putting up plexiglass partitions, having hand sanitizer, all the type things that we've been taught to do over the last year or so. You can have those in place, all designed to create a safe environment. The vaccine, does it impact this analysis? Absolutely, because it counters that indefinite accommodation requirement. All that said, you've got someone who's got comorbidities, they've got asthma, they're a cancer survivor, and they're asking to stay out longer. And so assume that you want everyone back on May 1st, and they're saying, based on what they're hearing from the CDC and from CNN and so on, that, well, herd immunity is not really hit in full force yet. I'd like to stay out till the fall, till September, when more and more people will be vaccinated. My practical advice is think long and hard before you mandate their return, if the window is short enough, right? If they say, I won't come back till next April, different issue. But if we're really talking a number of months, I wouldn't want to be that test case, because they're going to be sympathetic in front of a judge or a jury. And the way you would approach it is, first you'd have the interactive process, where you essentially start out, anytime you hear interactive process, think these words as the employer. How can I help? How can I help you be successful in your role where you can do all the job functions? And then it's a give and take, back and forth. And you're proposing, well, look, we've got hand sanitizer, we've got social distancing, we've got mandated mask wear, all these type things. And you're trying to find a way that will work for them, including, we're encouraging folks to get vaccinated. All right, next slide. How about the employee who says, I need to continue to work remotely, telework, because I have a family member at home, maybe an elderly relative, who's at higher risk of severe illness if they were to be exposed? Yeah, it makes perfect sense, right? If you're a caretaker, for instance, at night for your elderly mom or something like that, you may not want to run the risk. And certainly we can empathize with that. But legally, there's no requirement for an employer to accommodate based on your employee's association with a family member who otherwise has some type of comorbidity. The employee, him or herself, if they have the problem, they're entitled to an accommodation. The fact that the family member has the problem doesn't entitle them to an accommodation. Some paternalistic concerns. Back up one.
Sorry.
You have a employee who's pregnant, and you've seen enough, heard enough that you worry, oh my gosh, workers' comp concern. What if the individual were to get contract COVID here in the workplace? I worry for the mom. I worry for the unborn baby. And so, look, I'd rather have you not come into work. I'll keep paying you. You can work remotely. And the pregnant mom says, that's ridiculous. I want to come to work. I feel like, you're treating me differently. You're discriminating against me. The pregnant mom is correct. So you can't adopt a paternalistic concern just because you want to protect the mom and the baby. If they want to work, they're allowed to come into work. How about the employer who's requiring employees with known disabilities? So the person who's a cancer survivor, the person who's got immunocompromised system, you tell them, because they're at higher risk of severe illness, you're going to have them work remotely. Can you do that? Again, you're trying to protect the employee. You might even be trying to protect yourself in the event of a claim, because if they could trace it back to contracting the disease on site. And the answer is generally no. You can't do that. If the employee wants to come to work and kind of assume that risk, they're allowed to, unless you meet what's called the direct threat defense. So you don't ever have to look the other way if, by having the employee work on site, they pose a direct threat to themselves or others. Where this really normally shows up, just so you understand the direct threat defense, is you've got an employee who is somewhat mentally disturbed and it's ratcheting up, and they're making threats to coworkers. Well, you don't have to allow them to come on to the work site. They have a mental illness, which is a disability, but they're posing a direct threat. We're worried they're going to shoot someone, right? That's a direct threat defense. That works every time. In this instance, although the individual may be at higher risk, the direct threat defense is really a defense of last resort. We don't like to use it because it's a high bar. It's a significant risk of substantial harm. And you look at the duration of the risk. Here, the duration is going to be, maybe 6 months, right, until herd immunity. Nature and severity of the potential harm. It could be severe. We've seen 500,000 deaths. What's the likelihood of the harm occurring? In your workplace, if you're taking precautions, the likelihood is probably fairly remote that it would get contracted in the workplace, unless they're actually caring for COVID patients, right? Then the likelihood's bigger. And what's the imminence of the potential harm? Meaning, is it going to happen immediately? Again, most workplaces, the answer is no, because you take all those precautionary measures. So bottom line is, you're not going to want to, tell the employee just because they have a comorbidity, we're not going to allow them to come to work. And then the last scenarios I'm going to touch on, the CDC has stated if you're 65 and over, you're at higher risk of severe illness if you ever contract COVID-19. So how should you respond if an otherwise healthy 65-year-old says, I read the CDC guidance, it's obvious this hits older workers, older people in society harder than it does younger, by and large, not always, but from a statistical basis, that's true. And so I want to continue to work remotely. The answer is there is no reasonable accommodation requirement under the Age Discrimination in Employment Act. So the key to this question is otherwise healthy. If the individual has no comorbidities, no significant health concerns, you can easily say, no, it's a requirement that you come to work. But I would be careful because you're not going to know all their health concerns. So I would say to them, look, I'm going to need a doctor's note specifying why it is that you shouldn't come into the work site. And if all it is based on age, it doesn't get them there. But if instead it said, well, immunocompromised system, Crohn's disease, asthma, COPD, all those parade of horribles, then you'd want to do the interactive process and decide whether or not you should, based on the threat, the concern, whether or not you should go ahead and allow them to work remotely. Technically speaking, normally the answer is just the risk of contracting something isn't enough to say that they get the accommodation. That's legally, technically. What I'll tell you is, equitably speaking, the equities are going to favor the employee because of 500,000 deaths in the nation, the fear factor, and you're just going to have judges and juries who are going to be empathetic to that individual. If you were to say, I'm requiring you to come to work, they say, no, I'm not, and you fired them, right? So it's fairly complex to walk through. There will ultimately be clear answers once you walk through the factual analysis. And if you face any of these, certainly Amanda and I are happy to help. And I'll just give like a 12-second pitch on our firm. So Mirick O'Connell has about 65 lawyers, Boston, Westboro, and Worcester. We're a full-service business firm, but beyond that, we can assist on family law matters, guardianship issues, divorce matters. We have personal injury practice and business formation, anything that deals with business. And obviously for Amanda and I, it's employment litigation, HR advice. So if you ever find you need services, we're very responsive. We love working with our clients and we'd love to help out. And even if you just need a 2-minute conversation where we're not billing, we're happy to, kind of get a lay of the land for you and see if we can point you in the right direction, even if it means referring you elsewhere. So that's really quick and dirty, and we're happy to answer any questions. And we also thank Laura for the opportunity to present today.
Thanks, Bob. Thanks, Amanda. We appreciate it. All right. Are there any questions out there?
All right. Have a great day, folks.
You must have done a good job, Bob. You answered everything. Thank you so much. We appreciate it. And thanks, everybody, for popping on today. Thank you. Have a good day.
Bye. Bye.